Welcome to Health Law Talk, presented by Shahardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good morning, good afternoon, whenever you're listening to this podcast. Welcome back to another episode here of Health Law Talk here at Shahardy Sherman Williams. I, myself, Conrad Meyer, and joined in the studio today by my wonderful partners and I guess my colleagues, cohorts, brothers in arms, healthcare lawyers, corporate attorney, Rory Bellina, George Mueller, all of us here. Guys, how you doing?
Doing well. Good afternoon.
Good afternoon.
So today, as we sit here on a Thursday afternoon, it's Thursday here in Metairie, Louisiana, overlooking the beautiful Lake Pontchartrain, we decided to come on the show to talk about, I guess, just sort of a gumbo, that's what I called it, if you will, of some of the current kind of healthcare issues that we are facing for our clients. And we thought it would be best to come over and just have a discussion, a roundtable discussion about some of the issues we're all facing that might be beneficial to listeners who might want to, learn more about maybe some current hot topics that are going on. We agree?
Yep.
Guys?
Sounds great.
Okay. So I guess I chose the short straw, and I was told to go first. I don't know why, but I guess I'll go first. So, guys, one of the things that we were mentioning before the show started was I have a hospital client who's out of network with commercial payers who has historically been, fighting commercial payers for basically what's called the usual customary rate when they do procedures out of network. And of course, that's a very subjective determination that commercial payers use to reimburse facilities who are not under a contractual fee schedule. And interestingly, the way it has been a battle for like decades. I mean, this is not something that just popped up overnight, right? Because commercial payers want in-network facilities. However, a lot of times facilities don't want to agree to go in-network because the fee schedule is just so low. And so they just stay out of network. And so in this particular case, the client here has told me that what is going on is the commercial payers are telling their members that, hey, member, if you do not, if the hospital, the out-of-network hospital that you go to does not collect your required deductible, okay, for that service, okay, that then the commercial payer will refuse to pay any benefit to the member. Which really
on behalf of the member.
On behalf of the member. So interestingly, so it puts the member directly in the middle of this battle.
So the member essentially is getting a balance bill?
Absolutely, because they're out of network. So technically, on an out-of-network hospital, a facility or a provider can balance bill the member.
Correct.
100%.
So in this case, your client is the out-of-network hospital, and for one reason or another, since they're out of network,
right,
they're not. Well, they don't have the systems in place to really. Do they even have the systems in place to look up what the member's deductible would be?
Well, that's a good question.
I mean, do they typically? I mean, sometimes they have to phone in, right? Or they make contact.
So they do a pre-auth, right? They do a pre-auth, right? And they try to get a pre-auth for the service. In that point in time, the pre-auth, which we just did a show, correct, on the new law.
Verification of benefits, pre-auth, et cetera, whatever they have to do to make sure that they're kind of in the system, get paid or some whatever.
Absolutely.
They would typically kind of say, well, yeah, they still have a deductible of X, so you can collect that, copay.
Right.
Two different things, but, I think that's the time.
And so why would a hospital or provider not collect that deductible?
Well, I think sometimes it's used as sort of a marketing ploy to curry favor with patients.
We'll bill you later.
Well, we will collect it either. Sometimes they don't do it at all, right? Because you have the ability to waive the deductible, but if you're doing it consistently, which is I think what the claim is with the payers, like these hospitals aren't collecting the deductible at all.
And that's not an issue of an inducement because this is not. They're out of network and they're not billing it?
I was just going to ask about the I word, if that's an inducement. But, I mean, if they're not in network, then what's an inducement?
And that's the point. And so the point is, and I agree with both of you wholeheartedly, that if it's not an inducement because they're out of network, there's no contract. And so if they waive the deductible or they say, okay, patient, we'll collect your deductible on whatever terms we can agree on. Maybe it's a 12-month loan or whatever it might be, right? But then the commercial payer is saying if the hospital does not do that, then they are now, and they're putting this, I don't know if they're putting it in a summary plan benefit, like in some plan, like a in a PBS, within the plan documents, or are they sending this a separate cover letter to the members and saying, hey, if you don't pay the deductible, the hospital does not collect this deductible, we refuse to pay any benefit.
And from the insurance perspective, they consider this. The reason I'm speculating, the reason that they are not paying this is because they believe that by your hospital client not collecting the deductible, they are the patient could possibly being induced to having a procedure that might not be necessary. They don't have any skin in the game.
Well, not just necessary, right? Well, not necessary, but also out of network fee schedules. So, in other words, they know if it's an out of network fee schedule that hospital is going to come back and ask for a UCR payment, that it's going to be much higher, right, than the normal fee schedule would be for an in-network facility,
right?
And so, and then,
if you're looking at the total quantum due for the services, then you want the member to bear its fair share if they have an unsatisfied, amount.
And if the member is not paying anything, there's a risk that the member is getting a service that they might not get if they didn't.
Maybe not get, but also that service is now going to be charged at a much higher rate than an in-network facility.
They got to make it up.
That's right.
Okay.
That's right. They're going to. So suddenly you've got claims that are being sort of funneled due to this alleged inducement to out-of-network facilities who then bill the payors for the UCR rate, which is, of course, exacerbates because there's always going to be a difference of who believes what.
That and a payer figures into their total burden, right, with like the premiums they're going to collect plus full utilization of deductibles prior to, say, paying. So that
which might be a disincentive for services, so
right.
they might want to.
And if you did that across the plan,
yes,
imagine the financial effect.
So what happens when the hospital doesn't get paid anything and the insurance company says, go collect the full amount from the patient? Then the hospital has to make a decision. Are they going to bill and proceed against the patient?
Right. So that's my point.
After the service is already provided.
It puts the member right back in the middle of those crosshairs. And so now you've got a person who paid a premium, right, which is going to be the challenge. They paid a premium for a coverage model. So imagine if it was a POS or PPO plan that had an out-of-network benefit.
Right.
And suddenly what you paid for, you're being told, we're not going to satisfy that because your deductible wasn't paid at the time of service. And interestingly enough, the question becomes, in my mind, in my whatever brain I got here, is the deductible equivalent to the UCR rate of the procedure being performed? Because that's what they're saying. They're saying, well, wait a minute, if I don't have to pay anything, then you're saying that whatever deductible should have been paid by the patient should have just canceled it out? Bull. No, absolutely not. So now you've got a commercial payer who's basically saying, well, we're not going to pay anything, no benefit. You've got a hospital now who's going to have to go after the patient because of their out-of-network and balance bill the patient. But then suddenly you have a patient who says, well, wait a minute, the premium I've been paying is worthless. I really don't have a POS plan. I don't have a PPO plan.
So you have everyone pointing fingers at each other.
Yes. That's the conundrum that I'm facing right now.
It's the Spider-Man meme.
The Spider-Man meme of a triangle, three people all pointing air guns at each other.
I wish our listeners could see what y'all just did. That was great.
You would think that maybe the payer should at least step in and pay the amount net of what the deductible would have been had it been applied or collected, and or conditionalize paying that on them collecting that deductible. That way, there's kind of a sense of, I guess, equity, fair play, or putting them in the position that they should have been or are supposed to be, and then forcing that compliance. Right? I mean, I know that.
I mean, so some quantum Merowith argument on behalf of the facility, correct? Like back out the deductible.
Yeah, like and or say, yeah, we'll do it, but you still got to go collect it, conditionalize, versus just saying you didn't comply, so you get nothing, zero, go home. Because then you get the issue of, okay, what am I paying an insurance premium?
Correct. And that's the issue. So in other words, back out the UCR payment minus deductible and get that. That'll be it. And so you go get the deductible.
I guess the heavy-handed remedy is because naturally, I mean, the payer wants to induce, incentivize, or force compliance
to stay in network. Right?
So there's or at least comply and get the deductible paid.
So who is practicing medicine here? Just curious, guys. Who's practice? Is it because we have a corporate practice issue, right. No prohibition in Louisiana. So, but would you say that? And I'm not bad. I mean, I'm not naming insurance companies. I want to say that, but does this have an eerie feeling of a corporate practice issue?
Well, I'm curious, what does your client, the hospital, do in that case? Do they try to go after the patient, or do they try to fight the insurance company?
I think that's that's sort of what we're grappling with, right? Because I mean, what kind of marketing would it be for any facility to say, "Hey, even though we're out of network, we're going to come after you, patient, for all of it"? I mean, how many patients would want to come to that
It
hospital?
almost seems like it forces the insured, the patient, to go after its own insurer.
That's right.
And it's trying to force, I think, the facilities to get in network. Oh, if you get in network, you won't have this problem. You're going to get a
issue.
Well, if they allow them in network, because remember, sometimes they will just say, "Well, wait a minute, our network, remember, yeah, we have a closed network."
I would think that, I know personally I've encountered situations where they'll tell you what your deductible is. It's like they'll in their confirmation of benefits, verification of benefits, and setting it up and making sure they're doing everything they need to do, even maybe not even a pre-auth, but just whatever you typically do. When they do that, they'll come back and say, oh, by the way, here's your balance of we'll also have to collect this so we can get paid. And so you would think, I mean, it's easier to do that and everyone's happy, except the patient who has to pay it. But that's
well, let me ask you this. Well, what about solving the issue on the front end? Like, in other words, hospital, there's no delineation of how a hospital should collect the deductible. So can a hospital create terms for each patient that it sees beneficial for each? In other words, well, okay, we'll collect it. Pay me $100 now. We'll finance the deductible for you, patient, over a 12-month period, 20, whatever it might be, right? And then what if those patients just never got collected? I mean, you could then argue that you did try and make an attempt. What do y'all think of that?
Is that well, if they, so key to that is, what does the payer deem to be you've collected the deductible? Have you issued a note that you think is never going to get paid, or have you collected it in folding paper green prior to getting put in for surgery?
I mean, I'm sure the payer's going to say, we want, you can't have monopoly money here.
Do they establish that?
No, there's no.
Say,
and who's to say what that is?
So it's like, I'm not to be goofy English teacher here, Rory. So collected, past tense of collect. So it has to be collected. So is a note collected? I mean,
well, I think there has to be an attempt to collect it. So I think
is there a trend where some people are kind of giving a note for the collection of the deductible, or is this where you have to?
I think that's where most collections go. I mean, I think when you're out of network and you don't cover your deductible up front, right? They'll sort of float the note until it goes after collections.
And we see this also in the space where people are in network, and a lot of times in the pharmacy world, where a patient will go and they say, I can't afford my copay or my deductible, but I need this medicine, and the pharmacy will give it to them and work on payment plans, and sometimes they don't pay, and the pharmacy has to make the choices of hardship. Are we going to write this off? After a certain amount of time is trying to bill, but they've billed the insurance, they've filled the prescription, given the prescription to the patient. So I think that comes up right now, and that's an in-network example.
Mm-hmm. I mean, and it's a conundrum that I think is I mean, it's interesting for sure, but one that I don't think is going away, and I think that out-of-network facilities are going to have to grapple with.
Well, all right, here's another out-of-network insurance issue that we're facing is
it's a Rory problem.
Yes. So out-of-network provider, right, submits a claim to someone's out-of-network insurance, and insurance instead sends the check to the patient and says, patient, here's your check for services, but it's literally sent to the patient at the patient's house. So, and a patient gets a check and
they can spend it.
Right.
It's gone.
It's the same thing you do with the additional increased costs of compliance with the road home and the mitigation, everything.
Well,
it gets spent, it gets put on red, it gets brought to,
and that's by statute
and everything.
The statute now, if you look at some of the prompt pay laws and things like that issue that you mentioned, Rory, is a loop. Not I would call a loophole, but it's only attributable to physicians, but not hospitals. So in other words, if you have even out of network provider from a hospital, you still have to send the payment to the hospital. Okay, but physicians who are out of network, you're correct that it goes straight to the patients. And by the time a patient gets a $50,000 check, and that Dr. John Doe goes to that patient and says, "Hey, by the way, you got my $50,000 check. Can I have it?" And the patient says, "Ooh, I thought I hit the lottery." What do you do then? I don't know. Good luck.
Hire a
See, it's the
collection
same
attorney,
issue.
and then you end up,
But now
chasing
you're
that.
essentially suing your patients for.
You're suing patients, and if they've got the money, which they probably don't, then you're squeezing blood from a turnip and possibly bankrupting and, God knows what else to a patient because
there are multiple perils involved, not least of which could be, do they then turn into a malingerer or find a malpractice issue?
And why is the
That's another
insurance?
problem.
Why does the insurance company do this? Just to mess with the provider for not being in network?
I would suspect it is I don't want to say it's a consistent and organized punitive measure, but it may be that they don't have a contract with the provider, and so they feel they have to pay the only person with whom they do have a contract.
The member.
But the result is what we can't see, the audience can't see the grins on our faces, but obviously it has a punitive or negative impact or effect.
It punishes the physician for not being in network.
What came to mind immediately was that, I think body shops get a better deal in the state than the physicians. I mean, the body shops get the check and it's made to them all the time.
Or they hold your car.
Right,
Yeah,
or
for
you
that.
don't get the car, right?
Right, you have the collateral.
Whereas any personal services scenario, medical services,
And-
physician
and-
services, the services are already rendered, right? So
Right.
you're collecting on an open account from someone that already has the money, and then you're either battling their other secured creditors and or whatever. Plus, you as Conrad said, you're going after somebody who may not be able to afford it. And granted, the moral issue there is, of course, is that, they had the money, they could have afforded it had they not gone and spent it on something else other than what it was intended to be. So,
Right.
Because without the physician providing those services, they don't have that money in the first place.
That's
which
right.
is a critical
That's true.
leg on that stool. But that's a tough one. I guess until physicians band together and get a better lobbyist to change that rule.
I tried that. Let me tell you, I tried that about maybe 15 years ago. Tried it. Went all the way up to Baton Rouge. Sat down with DOI. Told them about exactly this issue, and to literally put something into law that didn't have that banned or prohibited PO boxes for payers to use as their notice requirements, right? Because everything gets lost in the PO box. You can't literally send certified mail to a PO box. So the prompt pay laws and all the other triggering notice provisions can't run on a PO box. Yet, amazingly, commercial payers notification, all their is always a PO box. Right.
Yep. Yeah.
Right. And I said exactly the same thing, Rory. Like, wait a minute, why can't hospitals have the favor of getting checks directly, even out of network, but then physicians can't? And I was basically told in no uncertain terms, good luck.
Right.
Good luck getting that passed. And it's commonsensical from a provider standpoint. But then
who's fighting that? Because I doubt it's not the public that's doing that.
No,
So you're saying it's the insurance
no.
companies that have that
It's providers.
locked up from a kind of a position issue or a position standpoint,
right.
or from a prevailing something that helps them help keep their networks intact, right, or to incentivize network membership.
Well, it presents problems from physicians who want to do out of network work on patients, because now they're faced with a sort of a double whammy of, hey, am I going to get paid, and how do I ensure that my patients who are going to receive the check, it gets to me without them going to cash it?
And what ability is there to make "quote unquote" assignment of benefits that's effective legally? I mean, if the check's made out to them and they go, you can't stop that, right? But
Well, that's even true. You've got a good point, George.
That's true.
Assignment of benefits. Even if the patients assign benefits in some sort of an assignment of benefits form for a physician on an out-of-network, the payers will not honor that.
they don't honor.
They
it,
don't
right?
honor
don't.
The point
They
they
don't
ignore.
honor.
They read it as not written. Right?
We've had that
been-
come through this firm where we sent the insurance company, here's the assignment of benefits that the patient signed in the hospital pre-procedure, saying send all payment for services rendered to X provider.
Nope.
And
didn't see it.
That's a negative, ghostwriter.
a
I mean,
payer,
it's not going to happen.
A payer just closes their eyes when that comes across their desk, and they just still send the check to patient's house, and patients spends it how they want.
They use it for kindling and fire. They would put Kleenex. They don't care.
Oh man.
That's the truth. I mean,
No.
well, I'm just saying.
Oh, the letter,
the
absolutely.
letter is the assignment is absolutely ignored. It is if it never happened.
Right.
And now you're faced with as a provider to say, what am I going to do? Right.
You're playing chase.
Chase with what? I mean, we all agree.
The hope of payment.
Good luck.
Right. Absolutely.
And then when they have to hire lawyers, right? Then they even get more frustrated because they say, wait a minute, at least I'm paying you.
Right.
I mean, I haven't even gotten paid for this, and it's been X amount of months, years, or whatever.
Sure. Something that's come up recently for a couple of different clients that I know, Conrad, I've talked with you about, and George, I'd love to get your opinion, are the medical legal cases and how practices handle those. Because a lot of times they'll get patients that come in and will say, I was in a car accident. I'm represented by attorney X. This is going to be a legal case. Yes, I have insurance, but we're not going to bill my insurance. Essentially send the bill to my attorney, and the practice makes the decision if they want to treat that patient or not and get paid at the end on essentially a cash basis, right?
Right.
But then, Conrad, I've talked with you about this, an issue arises where same fact situation, but let's say the case that looked really good, which is a bad way to describe it, but the case that looked really good for the attorney where he thought his client and the patient here was going to have a big recovery, doesn't look so good of a case now. But the patient still needs treatment, still needs surgery, has all these outstanding medicals, and the patient or the attorney directs the patient to say, you know what, this isn't working anymore. My attorney's not going to keep paying for my treatment. Now I want you to run my insurance.
Wow.
And that recently has come up, and it comes up sometimes, I think, on the front end and on the back end, and it causes a real issue for the practice, not only from an accounting standpoint, but from how they're going to handle it, because the rule is that if the patient wants their insurance and you or let's say you're in network with them, or even if you're not in network and they say bill your insurance, you have a choice of, are you going to discharge the patient or are you going to treat them and bill their insurance? But then is the insurance going to pay you? Because the insurance is going to find out it was an accident case.
They've got a significant delay in notice, right? So they didn't have the ability to steer or curate or otherwise manage from an administrative standpoint the course of care. And then you've got the subrogation issue,
yes,
right? Because naturally, first thing, whether it's Medicare or Medicaid or whether it's a payer, they're going to subrogate, right? I mean, they get the ability to kind of come back and participate in that claim to the extent it exists. They get reimbursed for all the stuff they're paying for because it wasn't their fault. And so, I think you've got a couple. I wonder about the delay, like the delay in claim. Like I've been treating for a year, but now I want it here. And, I think prompt engagement you have notification like any other insurance, right? In healthcare, it's a little bit different, right? But I think still, don't they have an initial? I wonder how do you get over the fact that you're really late to the game and making your initial claim?
Oh, you mean if the patient switches mid-treatment, saying, I'm going from a cash pay to now use my insurance? I don't know how the insurance I don't know.
I think when you're talking about
those costs going forward, or is it from day one?
No, I think costs going forward, right? It's got to be costs going forward, because that's expenditures that are being done now that are in relation to a tortfeasor. And
but it all is.
Technically it is, but it was never paid by the insurance company. So no subrogation right as to those payments that were never made.
But do they get to claim them? Do they get to claim them from T0? Like if
no.
So what he described is the case looks like a big hit, and then suddenly it's like, oh wow, maybe we have some comparative fault.
I don't think
it's not a comparative fault. Say maybe we have some culpability or something. You can't do that. Right?
How can't you do that?
No, I'm asking because
you can't. It's an overreach. How can you claim a subrogation right for payments that you didn't make?
No. What I'm saying is, what if the patient says, I've got all these costs, and they go back to T0 and present it to the insurance? Like,
the patient says, you've been treating me for 6 months, and you've just been kind of holding my bill, per se, until the case settles. And they say, my attorney says this case isn't worth anything anymore. Now I want you to go back and bill everything through insurance.
Well, I think you can. I think there's a cutoff for that. I think there's a time limit, a temporal.
Well, let's presume, just for argument's sake, let's presume that this is all within the 1 year from date of medical service. So what do you do as the practice? This whole time along, you've been treating
you submit the claims.
and
you've been holding them, and if you're in network,
well, that's the problem. So my problem is that the facts set the in network. So if you're
out of network?
That's different.
You're out of network. What
That's
do you do?
Different. You submit the claims
as out of network, and you're just. But okay, but now I'm the practice, and I submit all these claims that I thought were going to be cash. Now they're out of network, and I've been treating this patient for 6 months, however long. I'm going to get paid substantially less than I thought I was.
Yeah, or if you don't submit your claims timely relative to the date the service was presented, you don't get paid.
What if I did a surgery?
So if I'm out of network, if I got that question out of network, I tell them don't submit the claims because you're out of network. And I say you hold those claims, and then you, as the provider, file an intervention in that lawsuit,
like a lien in the lawsuit.
Absolutely, you get a lien for your bill charges.
But what if? All right, but the patient tells you, "I want you to bill my insurance."
No, you're out of network. I don't have to listen to you. I can bill whoever I want.
Okay.
Now, if you're in network, that's different. If you're in
network is different.
Network is different. So, but if you're not a network provider, I would say absolutely not. You don't patient sweet Sue. You don't tell me who to bill. I'll bill you. You know. But and then what you do is you tally your expenditures, right? Your bill charges, whatever, and then you file a medical lien because there is a medical lien statute.
Yep.
And you file the medical lien in the litigation.
And luckily, this practice had, we had set them up on the front end for this. They had essentially a contract with the patient saying that, you understand this is a legal cash case. We're not billing your insurance. Your attorney's responsible. If your attorney doesn't pay, you're responsible. And we had an agreement with the patient, but it seems to have come up a little bit more frequently than I've seen it in the past, where patients are switching from this cash amount to saying, I want to do insurance now, midway through treatment.
Well, I mean, this is a question. Your question is something I've dealt with clients. And, when you're in network, no question, you got a client comes in, hey, I'm in litigation case, but I'm also a Blue Cross member or an Aetna, whatever commercial payer you are, and you have a in-network contract with that payer, you don't have a choice. You've got to do the in-network, even if they call and they label it litigation. I mean, I think you run afoul of your in-network agreement. So
I agree.
So if they're out of network, to me, it's like the Wild Wild West for the providers. You can do whatever you want. Mm-hmm. You can balance bill. You could file the lien. You could do whatever you want.
Discharge the patient if
discharge. I'm firing you, and you follow the board's guidelines for terminating patient relationship. Mm-hmm. Yeah.
Okay. Mm-hmm. All right. What if you have a patient come to you that is an injury case, but they have insurance, and they tell you, "Yeah, it was an injury case, but I want you to use my insurance." What are you telling the practice of the provider then?
On an out-of-network or in-network?
In-network.
Well, you don't have a choice. In-network.
Correct.
So there's no choice.
But that provider is incentivized financially to convince that patient to not do their insurance.
But they also have a in-network agreement that requires them to do that, so they'd be in violation of that in-network agreement if they didn't.
Unless they can convince the patient to not run it through their insurance.
Do you want to run that risk? As a provider, do you want to run the risk?
No, but I have seen some clinics and providers that will say, essentially, I can get you in a lot faster if this is not run through your insurance.
Well, that's a UR issue, but I'm not telling my clients, do you want to play that game of chess? I don't.
I would not either.
I mean, that's like Russian roulette. Because then you're going to get kicked out.
Then you're going to that patient is going to call Blue Cross and say, "Hey, guess what Dr. Conrad's doing?"
Right.
And they're going to
they're going to do an audit, which they're required to do, and everybody knows this. They're going to pull the records, right, guys? And then guess what? You're going to be suddenly going to get that call. Guess what? You're out of the network and you're done.
Terminated. You're out. You don't want to do that.
And good luck with that.
Yeah.
Not worth the risk.
I thought I would just keep on the insurance
side
train that we've been discussing.
We have a lot of trains going on, man. That's your train. I got my Mueller. What kind of train? I mean, don't tell me. I know you have stuff in that caboose. I know you got it.
I don't have any.
You don't have any good, juicy.
I don't have any insurance specific things going on like that. I can't say that I do.
You can't speak to the insurance side.
No, not much.
No, that's all right.
We had something come up, you and I, a little while ago, George, and it was a deal that we had come late to, and there are some questions about the infamous healthcare laws section in the deal and how to approach that. I thought that was interesting. If you want to talk about that,
I refreshed my memory so I can go through my Rolodex, aged last century reference Rolodex of deals.
Yeah, so this was a deal that I think we weren't a part of the deal, but we were brought in to look at it after everything, and there were some possible indemnification claims being made, and we got to look at the actual deal documents and saw that there was a very huge, onerous, one-sided compliance with healthcare laws section.
Oh boy, yes, I do remember that. Yeah, that was remarkable. Again, hearkening back to our prior discussions of when we've really, you encounter, big practice roll up from private equity Inc.
Yep.
Comes in with big money center city law firm with an entail of associates, and the typical technique is about 2 or 3 weeks before you really get to a closing date.
The healthcare attorneys get involved. Right?
No, it's not just a healthcare attorney, because we don't do all healthcare attorneys injustice by referring to them this way, but it's usually the healthcare regulatory policy wonk, usually with poor social skills.
Not
wait a minute.
company not included, right?
Yeah, I think we have to exclude ourselves.
Present company not included.
Good.
That was implied, but for those of you who feel insecure, I'm happy you're able to self-identify and confirm. So, no. So they get brought in, and all of a sudden, with tripwire sensitivity, every potential regulatory issue of it could be referral patterns.
The minefield has been laid.
Or whatever thing is, it's just a self-report and pay and then nail ourselves to a cross and everything else, right? But it doesn't get levered in until like 2 or 3 weeks before the deal, right?
Right.
And then by then the thing's half cooked. Everyone's
You're exhausted.
committed, right? And you've got deal fatigue, and it's done like that on purpose to just, I think, hose the seller and or put in some more money in the escrow, and then to satisfy that if you don't do this, we're going to have all, and then it's all of the anti-kickback or stark rate or whatever other regulations being implicated has to be dealt with in a manner that is like zero risk, even though, you see the practical reality of it is this is a non-issue, right? And then if you were to, everyone just phone a friend and they're going to call someone in said regulatory department, like, oh yeah, we'll never see it. You can do it and we'll look at it in 18 months and cash a check and tell you a good day. That's it. And you're like, well, why are we doing this? And it's because the policy wonk with the poor social skills comes in and gives no deal materiality to it. It's just a yes or no, it's an on or off switch. And so in a case where you have, I guess we had, and for lack of a better term, I want to say it was sale, like medical equipment. Was it sales or something like that?
Mm-hmm.
I think without any attribution. And then I guess the manner in which some of those sales were being made or to whom they were being made had some offending component or characteristic to it. And then they did this on their own. They make their own little analysis of it. They make their own determination and then their own remittance.
Right towards the end of that holdback period about to be over.
Right. So if it's going to be 12 months or 18 months, magically this all comes up and they've got to make a big remittance and magically it's all coming out of the purchase price. And of course, as to the firm doing it, they get to keep their entail of associates busy, and then as to the entity, they just get to say, "Oh, we got to do this," and we're just saying it. So I guess to your point, negotiating exactly when that gets brought up in your deal overall is really important. We make kind of an announcement at the front end. We say, look, if you're going to bring up regulatory issues, you need to slate them before a particular date. You don't get to like edge them to the last part of the deal and then blow it all up and say, oh, the escrow's got to do this and we're sending a bunch of stuff and you guys stink and we think the purchase price has got to come down now and all that get it out, and it's like speak now forever hold your peace, because there's no lack of disclosure. It's just gamesmanship and strategy with how it's raised, when it's raised, and what the remedy is as it impacts the deal. So that's a
And Conrad, you would like how the buyer's counsel did this. They said, we think we need to make a remittance for a potential overpayment. We're not going to tell you exactly what it was or how much it was, but we're going to just do it, and you're on the hook for it but you can't be involved in it at all,
No,
essentially.
and we're not going to send you the full load of documents that pertain to it, although most of them are your business records.
All right.
Then we're not going to send you any of our analysis. We're just going to send you a generic sort of listing of billings in the relevant period, not identified or attributed to said characteristic.
That is,
And we're taking
that's
the money in
remarkable.
escrow.
Yeah,
That's
and
remarkable.
we're just going to hold the escrow and send it.
And they did a self-disclosure?
Well, they said they were going to do it, but again,
we
we
never got proof that they actually sent it or what they were doing with it.
so they said we're going to do a self-disclosure. We can't tell you how much and for what, because all that's confidential work product. But you're on the hook for the amount,
Yeah.
whatever we determine it
You
is.
know what? You know what that
The only way
sounds like
get
to
it
me?
was
It's-
they wanted to get an end, like a non-disclosure, but the non-disclosure just wasn't like keep it quiet, because I mean, really, the non-disclosure, the deal
Right.
document itself would still apply, but they wanted like waivers, like they were
Right.
just getting all
Waivers.
sorts of waivers as to any remedies in connection with the decision to do this, which is totally just
So not only
So-
do they not give you the documents for analysis, they don't tell you the amount that they're going to possibly remit. They also say that you have to waive any culpability
to
or
participate. Well, you don't get to participate. You get a really good seat. You get to view and see what the deal is,
Right.
view.
but you don't get to actually participate.
Wow,
Right.
And look, and so we raised
that's
this.
amazing.
Well, we raised it, and I think the issue is, and it's a really good example of why you have to get these things in writing, both to manage the client's expectations and then to remind yourself later is that,
Like on the front end.
yeah, because counsel for the sellers did raise it. They did say, hey, look, man, this is really like one-sided. But I think with that much leverage and that late into the deal, everyone just goes along to get along to close, and you literally have a scenario where counsel is saying, look, you need to view this as this escrow. You're never going to see it. All right, it's like it's gone. All right, like it's there, and you think it's there, but
Oh, they're going to bleed it
the
dry.
way this is written, it's gone. Just expect it. The issue is, what if it exceeds the escrow?
It's
Then
a slush
you're talking
fund.
about cost
It's a
containment.
slush fund.
Well, but you say that, but technically, it's supposed to go to the federal government in this curative.
But we don't know if they
remittance.
wrote a check. We don't know. We don't see the self-disclosure.
Well, that was, I mean, obviously, I think a couple of things we had kind of asked about was that, look, we like
Show me the check.
proof of payment. We want to see that it went there, and it just
Right.
says, oh, we're doing a big disclosure. We can't do anything about it, and just quiet, and then it goes.
Why can't you
Someone
have
else.
the actual self-disclosure?
Because they're holding the escrow. They didn't have like an escrow.
No,
agent.
no, but the document that actually goes, because it's a very specific document.
We asked for that, and
Yeah, we
we're
actually
told.
didn't get that either. We were going to do a FOIA request for it, but I think given the
That would
confrontational
be
nature of it,
Yeah,
I don't think it's subject to FOIA.
I
request. Is
wouldn't.
that
No,
right?
it's,
No,
it's
it's
not
not.
subject.
We got that
to
far
FOIA.
down the road with like, how can we verify they actually did this
Right.
versus, and I think
What
the
a
answer
bunch
is
of
no.
And even in this
garbage.
case,
That's
the
crazy.
escrow wasn't the seller's essential liability wasn't capped by the escrow.
No, it's just the escrow is just the money there. The cap, I think, was probably the purchase price,
Yeah.
right? Which is, it's another thing. It's fundamental reps. And this may have been in a fundamental rep, or they may have included the healthcare component of that in what would have been equivalently treated as a fundamental rep for purposes of, is it subject to tipping basket? Is it in the cap? And all that, right? And I think it was. I don't think it is. I
Yeah,
think it's-
and there were no. I remember you and I went over this a lot, George. There was no qualifiers. It just said seller reps and warrants that there have been no violations of healthcare laws, capital HCL, and healthcare laws is obviously Stark, AKS, Ketam, false
big-
claims,
That was a
paragraph.
defined term.
and the criminal stuff.
and the intent based. Yeah, the intent based
wow.
AKS, which I don't know how you give a rep and warrant on an
can't.
intent based statute.
How do you do that?
But-
Are you omniscient? I guess I don't know.
Well, with the subjective nature of it and how they do it,
Yeah.
basically, you're accused of it. So you do, and if you self-report, well, then you've completely kind of, I guess, skipped past the idea of what.
I would love to.
Or-
know.
or
Who was
you
on
get-
who was on the other side of that?
You
Who
get
was-
hit with a reverse false claims
I
act.
mean, you don't have to tell me the name, but was there real healthcare counsel on the other side of this deal? Like,
there,
or was
there
this?
was capable counsel, not healthcare specific. Probably, I wouldn't. They believe me. We discussed with them ad nauseum. They're very capable practitioners who raised all the issues. It's just a matter of the client wanted to go, was fine going through with it, and did so with the caveats of it. But what happens is through the passage of time, that
you forget how comfortable
all
you are.
that cautionary language tells you it falls to the wayside. Oh, I want this money. What do you
Right.
mean? It's like, no, you don't remember the parade of horrors that we visited you with and said, no, you're not going to get it. It's not going to be. I think there were emails even drafted, so I think they were protected.
Oh, so you got it.
I think, but people forget that. And I think the idea is you just still want to give it your best shot. But yeah, it's like, what do you do?
And you get excited when that anniversary is coming up and you think you're going to get another check in the mail.
I'm getting that money. Well, they shouldn't do that, and boom, they do it. But you don't even know where they really spent it, right? If you had an escrow agent, it'd be a way different deal because the escrow agent would at least let you know, yes, we did cut a check and it was to a governmental agency.
Right. So just for our listeners who might not be attuned to what all this means, because I could tell you we've had a lot of some very interesting topics brought up. So in a healthcare deal, when you have alleged some sort of a fraud and abuse, the regulatory avenues that you can pursue include some sort of a self-disclosure protocol, and that protocol. They have two different self-disclosure protocols, and so and those have specific things you need to do. And in this particular case, George and Rory, correct me if I'm wrong, that there was a unilateral dictated move to do the self-disclosure protocol with an also unilateral requirement for some sort of a large escrow related to paying off any kind of overcharges or overpayments to the government. Without giving you the actual knowledge of the analysis behind it, the amount in question, and so forth. Is that fair?
I would say our client was basically sent a letter saying, "Hey, we're putting you on notice that we're doing this, and you're responsible for it, and but that's all you're going to get."
Wow! And they kept trying to get us to sign the client to sign the waiver to get the information. I'm like, well, why would we do that? You're not going to tell us anything anyway.
You're not going to let us help, right?
I don't. We'll let you know. I think what that turns into then is on the date when the escrow is otherwise due, you make a demand for that, and then you force the response. Right. And when the response is what we would deem insufficient, then you evaluate your legal rights under the applicable law to say, well, we're going to demand it, and you force, and then they probably just hide behind the fact that you waive this, you can't do that, et cetera.
And even in the amount that was being held in escrow, I don't believe it was a lot. Even in that amount, in the deal documents, it said that any sort of investigation, attorney fees and cost would be eaten out of that escrow.
Oh yeah.
Oh, so they have their own incentive.
Yeah, the more you push, the more the anthill gets.
So they could bill against the escrow that they're holding to do an investigation on their own.
They get to pay themselves in a pool of money that they determine what that size is, right? Without sharing any knowledge whatsoever. Wow.
And it's stunning then that Healthcare Compliance Council would find something that they actually needed to report.
So there is a pot of gold at the end of the rainbow. If you decide the size of the rainbow, the bigger the pot, the how gold,
if you
right?
build in those types of terms in your escrows and your indemnities, then you really have to watch who's driving the traffic and the reporting advices, right? Because it gets to be kind of, I'm not saying that's what's going on, but you just have to kind of watch that.
You know what it reminds me of real quick is remember like the BP oil spill. And the reason I'm saying this is because remember and I don't know if maybe I'm saying this wrong, but there was like $1 billion put into a fund or something like that. Remember the BP oil spill?
I do.
And there was someone in charge, I forgot who it was, a firm or a man or somebody or a company that was in charge to allocate payments of funds based on BP oil money. And that person basically was literally had a checkbook. And then they could also then take out their fees associated with administering the fund. So here someone is sitting on top of this pool of money that they're responsible to divvy up for victims, but then they also get to pay themselves from the same pool of money, whatever rate, even if it was a fixed rate. I mean, but they get to pay themselves. So this is akin to that. So I mean, imagine if we had a pool of money that we get to determine the size of, how we pay ourselves, and we don't get to tell anybody what that looks like. Wow.
Yeah, that's
wow.
So
I want that deal.
So, and I'm sure whoever did the BP payments did everything by the book.
I'm sure. I'm not saying that. I'm not saying they did. I'm just saying it. I'm analogizing to it. I'm not going to walk down that rabbit hole.
Okay. I think we need to climb out of that rabbit hole.
We are coming. So anyway. Yeah. Anyway, so I think it's good. Well, you know.
So that's definitely an interesting. We're running late on time, and to kind of wrap that up, you know, you have to build that in on the front end, because in the back end you're going to get taken to the woodshed on it. But that's how those things work sometimes.
That's very interesting. Well, we covered a lot of stuff today in our gumbo conversation. That was really good.
It was good.
Definitely
Good conversations.
Any final thoughts? Any words of wisdom? Nuggets of information? I think we've given them all today.
Think we're good.
We're good?
Absolutely.
Okay. Well, look, everyone, we want to thank you very much for listening to another episode of Health Law Talk here at Shahardi Sherman Williams. We are George, Rory, Conrad, your, disseminators of legal healthcare and corporate knowledge to the listening ship. We thank you very much for your time and look forward to our next episode. Have a great day. See you.
Thanks for listening to this episode of Health Law Talk, presented by Shahardi Sherman Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardi Sherman Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardi Sherman Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.